Alrighty then. So, hello again. This is Ken Smith. I am the Central Washington accounting professor, and looking at some of the actions by the Kent School Board. One of the concerns is a contract extension addendum that they did at their August 22nd board meeting, and I'm going to show you what I think happened and some concerns I have with that. So, brief slides here. So first off, I'll go through the facts of the case as I understand them, the acts by the board as they were visible, the problems I see, and some fixes they could go through. So in terms of the facts, there are three real contracts going on here. In 2017, there was a contract that was posted at their board docs website. There was also a 2017 contract that apparently was signed, that apparently was a different contract that they signed other than the one that they were voting on that the public would have seen at the record, and that's its own set of problems. And then there's the 2018 addendum contract. The 2017 signed is I would not think legally enforceable, would have to get a legal opinion, but it's different than what they voted on. They did not change the contract while they were going through the meeting, and so the only way a board can act is in public and have a quorum. So if they wanted to modify terms, it should have come back to the board and modified that. Third point, regardless of which 2017 version they're using, neither of them extended the contract to 2021. I'll show you that shortly. And then many community members were opposed to this extension. There have been multiple votes of no confidence on the superintendent, and there's also at least 2 unresolved complaints following the 4312 procedure, and one of which includes a conflict of interest concerns. And I have said earlier, I'm surprised, and I would not give you a contract extension for someone who has currently had unresolved complaints against them. So here is the first contract, and when you see the language here, it says if the contract is not to be extended beyond 2020, the board must give written notice no later than July of 2019. So July 2019 has not yet occurred. So this provision of the contract is not in operation. Some people were saying that it automatically rolled over, and it did not, because this contract provision would not have kicked in by July of 2019. So this contract, they call this the alleged draft contract, but it's not been posted, it's not been, it did not have the operation of causing an extension because the date had not yet been met. So if this is the accurate contract, there was not an extension. Secondly, in the statement that the board president gave on August 24th said, oh, there was a different contract, and this is the one, but when you read the language here, it says if this contract is not to be extended beyond 2019, the board must give written notice no later than July of 2018. Well, July of 2018 had passed, and so since they had not given notice, apparently, for that, the board had to give written notice if it was going to go beyond 2019. Absent such notice, which apparently they did not give, and they did not give it in public, the board affirms the contract is renewed to 2020. Well, 2020 is the extension of the contract, is the date of the contract, both under this signed contract that the public had not seen, as well as the original contract that the public had seen. So then when this contract was put out on August 22nd of this year, it says that this contract is renewed through June of 2021. So the contract they voted on, even though some of the board directors said we're not voting on an extension, they actually were. The board was incorrectly under the assumption, and we don't exactly know who told them or why they told them that this contract had already automatically rolled to 2021, and neither of the contracts that they could have used caused that to happen. So that's a big concern. All right, so then we'll move on to the, so here's the summary of what the board did. Prior to August, they must have discussed this contract in exec session, likely more than once with both the lawyer and the superintendent in the room. And that would be normal procedure, is to have tried to come into terms that could be agreeable, but they could not take formal binding action until the board met in public. The board was confused if this 28 contract was an extension. For some reason, they were, I would say, misled, led to believe that it had. During the public meeting, the board did not dig into the details of the confusion. They did not ask the superintendent, and they did not ask the lawyer. That, I think, is very bad board behavior. As a former board director myself, whenever you have a question, especially about something as important as the contract with the superintendent, should always make sure you're completely clear about what it is that you're voting on. It's a huge obligation. You have a fiduciary duty as a board member to do that, and I don't believe the Kent board did that in this instance. Okay, so then one of the board directors, Director Ross Hardy, asked if they could table the motion, and it's a little hard to hear. There's two different videos, but what I heard is that the lawyer said no, you could not make a motion to table, you had to vote. They did the vote, and then they tried to kind of sort of go back to the table, and they'd already done the vote, and there was significant confusion. And so Director Hardy's approach and request to do that was not honored, and I think partly due to incorrect advice. The board did vote with 3 yes votes and 1 no vote, and then there was 1 abstention. And then 2 days after the vote, the board president issued a written statement, and this statement is at the school board website, and it talks that the contract on file was a draft document, said it was posted in error. The draft document contained a date they say is wrong. They said the after previously quoted contract also stated a certain date, and the contract should have read. Now, I take great issue with this notion of should have read. A contract is the contract. What party signed is what operates. And if they signed something that was incorrect or did not capture their meaning, they should fix that. For a contract like this with the board and a superintendent, it would need to be done in a public meeting. And then, so there's no way that the contract language has this automatic rollover. That's just not a fact. Bullet point here says due to the fact. It's not a fact. And so I think that's definitely problematic. Okay. The other part is that in board work, and not everyone understands this, but the board's president has the responsibility to make statements on behalf of the board in between board meetings, and they're not allowed to meet with a quorum, with the majority of them outside of public. So when a board president makes a statement like this, that's proper for the board president to make a statement, but that statement then has to be ratified, reviewed, modified, accepted, or rejected by the board as a whole. So this statement is a kind of temporary statement until the full board meets again, and they meet again in 2 days. And they should take this up, in my opinion, and in my opinion, I think they should change the statement and revise it, because it's not materially correct, in my opinion. Okay, and then, so what are some of the problems here? The board apparently did not read the prior contract before the meeting, or at least did not have access with it at that point. They had come to an understanding. They did not pull up the contracts on the screen to clarify. For an accountable board, that's what you would have done, to say, no, let's make sure there's no confusion to fulfill their public fiduciary duty. They did not ask the lawyer in that meeting for the legal advice, which would be useful because it's a legal topic and you have a professional there to help you. And they did not ask the superintendent. The superintendent serves as the secretary to the board and has a responsibility to help the board not make mistakes and not make decisions without information. And so as the professional advisor to the board, that was a problem, both that the board did not ask and the superintendent did not provide that help. They did not handle the question to table accurately, and then again, I do not believe the statement in the president's statement is correct in terms of a should have. So what would I do if I were on that board? And I've been on a board before. And whenever you make mistakes, you need to fix mistakes. So first, I would petition, if I were a board member, I'd write an email to the board president and say, hey, please bring a different lawyer to the board meeting so that we can have a second opinion on these matters. And it needs to be done in public because the public, is the one that understands, pays the taxes and feels the results of this particular activities. Secondly, I'd make a motion to consider if any board director had a conflict of interest in regards to the contract. One of the concerns with one of the complaints is that all the travel that should have been approved by the board. The contract says by the board. Well, the board is a technical meaning, the full board. The board president is not the board, is just the board president. And so no travel, we've not been able to find any travel authorizations in the board documents, official record, so therefore it was not approved, and then there's a problem with the board and the superintendent because the board president was apparently approving something they did not actually have the legal power to do that. So I would ask to make sure that we reconsidered if anyone had a conflict of interest, and two of the board members, two of them that voted in favor of this contract, Director DeBruler used to be the board president when she approved some travel, and we've seen evidence of that. And then current board president Bengadassalam also has said verbally that she approved travel, or that the travel was approved. Third, I would make a motion to review the August 24th statement by the board president and modify as needed. This is absolutely, I think, necessary so that the full board gets into the details and make sure they're clear and understand what they did, and that the statement accurately reflects it. I then would make a motion to remove this should have phrase. I don't think that's accurate, and let me just double check. The should have phrase is actually in item number 3. So that's, we all make mistakes, and this is the whole point. That should say item number 3. Okay, and that's normal. It's okay to make mistakes. What's not okay is to cover up your mistakes. And then if any additional information is needed, which it might be, given the complexity of this, I would postpone it to the next meeting, but basically not support, not ratify the statement by the board president. Then I would go into, and I have seen in some of the other items on this particular board meeting, I think the board is making some significant steps and really trying to improve their performance with their board goals, strategic plan, etc. So just because you make mistakes doesn't mean that you also aren't doing some things well. And I think the board goals is a significant positive step forward. But I would ask to renegotiate the contract with the superintendent. I don't believe the public wants, and I don't believe it's justified to give a contract extension. That's my strongly held opinion for someone that's under the kind of complaints and investigation that the superintendent should be under right now, and come to a resolution in that before you extend them a third year. So I would, if I were on the board, make a motion to re-enter contract negotiations with the superintendent with the goal of removing the extension to 2021 or making that extension contingent on a quality performance review for the 18-19 year. And as I said, the board is making progress steps. Their board goals that they'll be voting on Wednesday night, the 12th, also has a concept there of quarterly reviews of the superintendent's performance, which is a great step forward. So in the conclusion, I do not believe the board effectively considered and voted on the superintendent's contract, and I believe they should take corrective action. I've given some that I would do, and such that they're diligent in their fiduciary duties and rebuild trust with their district's constituents. So I try to keep this as short as possible. I know I talk a little too fast, but want people to understand some of the concerns, the foundation for the concerns, and then ways that they can correct so they can move forward. And then I think then that helps everyone in the Kent district to work together to make things better for their students.